Yes, Mr Morris.
My Lords, good morning. I appear for the appellant, Mr Gale, next to me for the respondent.
Good morning.
My Lords, let me start off by setting out what I propose to do. I propose to break my submissions into 5 different sections. What I want to do first is just to set out what my case is, leaving aside for the time being Section 75 of the 1925 Act and also the approach of the judges below. Having done that, I propose then to analyse the respondent's case. And thirdly, using that analysis as a springboard, I propose then to come to the 2 judgments below. And fourthly, using that analysis as a further prism, I then propose to turn to Section 75 of the 1925 Act and why I say that still is the crux of this appeal. And then finally, I will address what I anticipate my learned friend to be saying orally by way of developing his written case.
Yes, thank you.
Before I embark on that...
Have we got some general time frame?
My Lord, subject, of course, to those questions that your Lordships will ask me.
There will be some.
There will be some, no doubt. I would anticipate, I think, probably finishing before lunch.
Yes.
And giving way to my learned friend before lunch. I may have some things to say in reply, not least in relation to the further authority that I think is being relied upon today that's been handed up to your Lordships. Before I embark on that, my Lords, I wonder whether it would assist if I just, by reference to some of the plans in the bundle, talked you through the layout of the land and the relevant properties, just to make sure everyone has their bearings.
There's no harm about that, because of course the plans find their way upside down, sideways and so forth, so it's sometimes not particularly easy to follow exactly.
Indeed. Well, my Lord, let me start off by doing that then. Hopefully your Lordships will have picked up that Mr and Mrs Wright, who are the 3rd and the 4th claimant, own 2 properties on a road called The Green in a village called Thrussington in Leicestershire. Now, they acquired title to the first of those properties, which is number 26 The Green, on the 13th of February 1984. And that was a cottage which was attached to the adjoining cottage, number 25 The Green. They purchased number 25 The Green on the 25th of November 1988. I should say those dates are the dates on which they were registered, not the dates on which the transactions completed by deed. What they then did is to knock those 2 properties together, so that although they are still registered in 2 separate titles, that is just one dwelling house, which is their family home. The Claphams, who are the 1st and the 2nd claimant, acquired the next door property, which is not attached. That's called number 24 The Green, and they acquired that in November 1996. And if I could take your Lordships to the title plan for Brook Barn, which is the respondent's property, behind the particulars of claim, so that's the main bundle, tab 11, and on page 230. This is the clearest place for bearings to be obtained. So what your Lordships will see within the red line on this plan is Brook Barn, that is the respondent's property. And then to the south of that, immediately to the southern bit of the easternmost part of Brook Barn, you will see a building with the number 26 written in it. So that is the Wright's house. And although it's now called number 26, as I've explained, it was formerly 2 separate cottages, and it is still registered in 2 separate titles. And then just to the left, or to the west of that, you will see number 24, which is the Clapham's property. And then, my Lords, you will see The Green, which is a street running just to the south of all of the properties. And not clear on this plan, but I'll show you where it is in a second, you will also see that there is an indication of a brook running between the appellant's property and the respondent's property. Now, to get a sense of the land in dispute, it's helpful to go to the sketch plans, which were also exhibited to the particulars of claim. So, staying behind tab 11, my Lords, if I can take you to page 241. And as my Lord Justice Jack's indicated earlier, it might be necessary to rotate this plan so that it faces north. So what one sees here within the red line is the Wright's property, number 26 as it's called. And one can see the line of the brook running to the north. And my lords, I just invite you to ignore for the time being the red line. This was obviously prepared as part of the claim below. But one can see the brook running between the properties. At the very northeastern corner of their property, you can see a bridge which spanned the brook and gave access to the north bank. And then coming further to the west, one then sees number 24, the brook again running to the north. If your lordships look a little bit to the north of the line of the brook, you will see a fence. That's an important fence because our case was that the appellants all had title up to that fence, either on a construction of the conveyances or through adverse possession. And my lords, you may have picked up, though it's not relevant to what we have to consider today, that there was another piece of land in dispute which was called the treehouse land. That you will see just to the western edge, the treehouse is marked. So it's to the south of the brook, but outside what was agreed to be the line of the Clapham's registered title. So the land that we're talking about in dispute here, my lords, runs broadly from the south bank of the line of the brook up to the fence. And although I accept this is only a sketch plan, one gets a sense of the dimensions which are involved by looking at it. This is loosely based on a GPS survey which was carried out. There's a scale in the bottom left-hand corner which indicates 10 metres. So roughly speaking, though I accept that this isn't completely accurate, my lords, you will get a sense of how many metres of land we're talking about. In places it is barely more than a metre, as it runs, in places barely more than a couple of metres. At the widest point, perhaps right on the western edge, it's a little bit more. But at no
western edge, that's the dotted blue line, is it?
Yes, my lord. So the western edge beyond the line of the Clapham's property, you will see, or just above the treehouse land, there you will see that the south bank of the brook and the fence span maybe, looking at this plan, maybe about 5 metres.
Thank you.
So between a couple of metres and 5 metres is the size of the strip, something of that?
Broadly speaking, my lord, yes. Yes, I accept that the trial judge, of course, had the benefit of a sight.
Matter at all, but I mean, just to give us a sense of...
Indeed. So that, I hope, gives your lordships a picture of the land we're arguing about. A point to emphasise in case it's been missed is that Ms Narga, the respondent, only appeared on the scene fairly recently in 2020. And what she did was to take her land registry title plan and to assert that her land included land which went beyond the south bank of the brook. It in fact went right to the top of the bank of the brook and beyond. And at one point, my lords, you may have picked up from the judgment of His Honour Judge Hedley, the trial judge, Ms Narga erected unilaterally a fence which ran through what was indisputably part of the claimant's garden, the appellant's garden. She started clearing the land on one side of that and started to demand a licence fee for that land to be used.
Situating what you're saying within the plan that we've got in front of us, what are you describing?
So, my lord, at one point the fence that Ms Narga erected was above the, south of the south bank of the brook. But actually the fence was beyond the top of that bank. And actually it was running through, over the lawn, essentially, which ran between the property and the top of the bank.
She was mapping the title plan onto the ground, and that, she thought, gave her some distance south of the south bank.
My lord, exactly so, yes.
Was this dotted blue line on this sketch plan what the filed plan of Brookbarn showed, or what is it?
So, my lord, the dotted blue plan, the dotted blue line, I think, my lord, what that was intended to denote was the top of the bank of the brook. So, just, it's a subtle nuance, but His Honour Judge Hedley said the boundary follows the northern edge of the south bank of the brook. So what he contemplated was the water line essentially at low water, where there were some features along part of it, pinion walls and so on. But beyond that, there was a steep slope.
Yes.
And that goes beyond where His Honour Judge Hedley determined the boundary to be. And then from the top of that slope, it then opens up into the lawn which forms the claimant's gardens.
And when you were talking about Ms Narga having put new fencing in place, was that roughly along the line that we see as the blue dotted line?
So it was to the south of what we see as the blue dotted line, broadly speaking, though I accept that this plan is a sketch plan, so it's not
indicative, I
exact.
understand that, but I mean, it was some way further south of the dotted line.
Indeed, my lord, it was essentially across part of the lawn.
If we look at the next page,
Yes.
242, does that help at all?
It does. So, my lord, this is another sketch plan, but what this is intended to show is the boundary features as they appear from number 24, the green, so the Clapham's property.
Yeah.
And what one sees here is the, in fact, my lord, I think this is helpful, one sees the edge of the brook line and then the steep bank beyond that.
A very steep bank.
Very steep bank, quite so, with steps giving access down to the line of the brook, and a hedge and fence along the top of the bank.
And is that a fence that Mr Narga erected, or is it one that was there already?
No, my lord, that is the Clapham's fence, and what His Honour Judge Hedley found was that that was not intended to be a boundary feature. Its purpose was simply to stop people from falling down the very steep bank.
Right, so does this help us to envision where Miss Narga's fence was?
No, my lord, because that part of the fence which ran through the garden was across the Wright's property. So back on the previous page.
Yes, I see, so we're in 24 here.
Yes. Yes. And as my instructor points out, that fence was dismantled and removed. But this precipitated the dispute and resulted in the interim injunction being obtained.
So sorry, she put it up and you took it down.
Yes, I think. Yes, the exact sequence of events is recorded in His Honour Judge Hedley's judgment. As I recall, my lord, it was put up by Ms Narga and it was taken down by the Wrights, and I'll confirm that point over lunch if I may, because I'll just have to dive back into the very comprehensive judgment of the trial judge.
Okay.
But my lord, nothing specifically turns on that. I'm simply illustrating the origin of the dispute. But there is one point here which it is important not to lose sight of, which is that Ms Narga's case at trial was that her registered land included land that went up to the top of the bank at least, and that was rejected by His Honour Judge Hedley. And so he did find that she was liable in trespass in respect of what she'd done south of the brook. He ordered her to pay damages, and he also ordered her to pay some of the claimant's costs.
How much has been spent on this dispute by each side so far?
My lord, I confess that I don't know. It is...
Nobody ever knows the answer to that question in
well,
these cases, but by the time we finish this appeal, they will. So
Yes.
could we have from both sides, please?
Of course, my lord.
Have to be today. Costs up to first trial,
Yes.
costs up to first appeal, and costs up to the end of this appeal.
Yes, my lord, we will sort that out. I make those points, though, my lord, partly to illuminate the origin of the dispute, but also just to emphasise the importance of this dispute, notwithstanding its costs to the parties, and of course to the issue in this appeal. So, having done that, let me come on to the first section of my submissions. So, I want to set out what I say the legal answer to all of this is, leaving aside section 75. So, my lords, if you could take up the authorities bundle, and because title to Ms Narga's property, Brook Barn, was registered just under the 1925 Act, it's there that we start. So that's behind tab 1. And my lords, if we could start with section 5 of that Act on page 8 of the authorities bundle. So, my lords, it is this section which deals with the effect of first registration of title under the 1925 Act. And, my lords, you will see, well, it speaks for itself. Essentially, title takes effect subject to such overriding interests as affect the registered land. But more important for today's purposes is section 69 on page 10. which deals with the effect of registration on the legal estate. And this is the predecessor to section 58 of the 2002 Act, the so-called statutory magic provision. And what it tells us is that the proprietor of land who is registered shall be deemed to have vested in him, without any conveyance, where the registered land is freehold, the legal estate in fee simple in possession, and where the registered land is leasehold, the legal term created by the registered lease, but subject to the overriding interests, if any. So this is an important provision because it deems someone to be the owner even if in fact they should not have been registered as the owner of a particular piece of land. Now, importantly, section 69 was qualified by the predecessor to section 60 of the 2002 Act. So the general boundaries principle or rule contained within the 1925 Act scheme. That was in fact contained in the Land Registration Rules of 1925, which your Lordships will find behind tab 2 and on page 20. So this is the relevant rule. It starts off by saying that, except in cases in which it is noted in the property register that the boundaries have been fixed, which is the language used by the 1925 Act, the 2002 Act talks about boundaries having been determined, the filed plan, or the general map, shall be deemed to indicate the general boundaries only. And then sub-rule 2, in such cases, the exact line of the boundary will be left undetermined, as, for instance, whether it includes a hedge or wall and ditch, or runs along the centre of a wall or fence, or its inner or outer face, or how far it runs within or beyond it, or whether or not the land registered includes the whole or any portion of an adjoining road or stream. And my lord, also worth noting sub-rule 4, this rule shall apply notwithstanding that a part of the whole or the whole of a ditch, wall, fence, road, stream or other boundary is expressly included in or excluded from the title, or that it forms the whole of the land comprised in the title. So it's a powerful rule under the 1925 Act, and it is in fact set out in more wordily, if I can put it like that, than the same rule in the 2002 Act, which simply says a title plan shows a general boundary without telling us any more about what that means.
And subsection 3 suggests that if you want to have a fixed boundary, you need to give notice to everybody who's adjoining.
Yes, my lord, this isn't in the authorities bundle, but there is a separate provision in the rules which deals with, or rather which dealt with, how one went about applying for a fixed boundary under the scheme of the 1925 Act. And under those circumstances, of course, notice would need to be given, as indeed it does under the 2002 Act.
Which was likely to just generate a large number of disputes.
Yes, well, what the Law Commission recognised before the 2002 Act was enacted is that very few boundaries were in fact fixed. And it's part of the reason, I think, why they thought that maintaining the general boundaries rule in the scheme of the 2002 Act would be desirable.
But because you don't need to give notice to the owners of adjoining lands, you might be sitting there and your neighbour's property might be sold with a boundary, a general boundary, and you know nothing about it.
Indeed, my lord. Or indeed registered for the first time with a general boundary and you'd know nothing about it.
And you wouldn't have any reason to check the register to see quite what was shown on their filed plan. It wouldn't matter because
it's a general boundary.
it's a general boundary.
And it's conclusive only, also registration under the 1925 Act, which is one of my central points, is that registration is conclusive as to who owns an estate, but not as to what they actually own. Sorry, let me put that slightly differently. Not as to the full extent of what they own.
Physical extent.
Exactly, my lord, or the boundaries of what they have been registered with. So one looks at...
Just pause.
Sorry, my lord. So one would look at the title plan and one would see approximately where in the world this estate was. But the line on the plan would not necessarily tell one about, it would not tell one about the limits, the exact delineation of the limits of the estate unless the boundary had been fixed under rules. Now, at that point, I pivot slightly to say there is another possibility under the scheme of the 1925 Act, which takes us into this territory of the difference between a boundary dispute and a property dispute. Because a person might wrongly have been registered as the proprietor of an estate in land to which they had no title. For instance, because the title had previously been extinguished under the Limitation Acts.
So if the Claphams and Wrights had taken adverse possession of the whole of Brook Barn,
Yes,
and for a sufficiently long period to extinguish the title
Yes.
of Brook Barn, but nevertheless Brook Barn was registered,
yes.
then what would be the position?
So the position then, my lord, would be that Ms Narga would have, or sorry, her predecessors in title, would wrongly have been registered as the holder of title to an estate when in fact the person, the vendor who sold it to them had no title to give them.
But still, by virtue of a statutory magic, get a fee simple, a statutory fee simple.
Indeed, they would. So that is the extreme case of the title dispute, sorry, the property dispute that the authorities talk about. It is a question of fact and degree, I think we're agreed on that, where the line is to be drawn between what is a boundary dispute and what is a property dispute. But where someone is wrongly registered with title to all of an estate where that title doesn't exist, that is plainly a mistake, it is plainly a property dispute. And if,
do we have to resolve whether this is properly characterised as a property dispute or a boundary dispute? Mr Justice Leech said he didn't have to decide it, but he was inclined to think that you were right, it was a boundary dispute.
Indeed, my lord, but as I understand my learned friend's case, he is going to ask your lordships to decide it, and he is going to contend before your lordships today that this, in fact, all along was a property dispute and not a boundary dispute. And I don't want to trespass on my learned friend's submissions, but what your lordships may have picked up is that he is his defence of the Section 75 analysis is not particularly, if I can, no disrespect intended to him, not particularly full-throated, because what he now says is that even if the judges were wrong in their analysis of Section 75, there is nonetheless a basis on which Ms Narga can identify a root of her title today. But
that it's a property dispute.
Yes, but I'll come on to that, my lord, if I may, when I move on to the next section of my submissions.
And just to be clear, your contention before us is that it is a boundary dispute.
It is, my lord, yes, and I'll come on to that.
But am I right in thinking that's quite an important step in your case?
It is. Yes, it is. It's fundamental because what I say is that the operation of the general boundaries rule in a case like that, which your lordship put to me a second ago, where someone has their title registered without having to give notice to their neighbour never knows. It is fundamental to the operation of the scheme that the general boundaries rule, as I put it in writing, takes the edge off the conclusiveness of registration precisely to enable the underlying paper title boundary to survive.
I mean, my suspicion is that this point is actually crucial, in the sense that even supposing that you're right that Section 75 doesn't apply, then if it is a property dispute as opposed to a boundary dispute, then what you would have had presumably would have been a right to apply for alteration or rectification. And then it isn't obvious that that right would have survived the sale to Ms Narga.
Indeed, my lord, yes. Yes, I accept that.
Which means it is absolutely crucial whether it's a boundary dispute or a property dispute.
Yes, although of course my submission, and again I'll develop this, my submission is that His Honour Judge Hedley treated this as a case to which the general boundaries rule applied, by which I mean he treated the land in dispute as falling within the general boundaries rule. And Mr Justice Leech was clearly also of that view.
And in either in support of that case or in defending the argument that we'll hear from Mr Leech, you point to what we were looking at on the plans and the sort of scale of the land that was involved and the way in which the issue came up as having all the, what one might call, badges of a boundary dispute.
Yes, and that might be a charitable way of putting it, but yes, all of the horrors of a boundary dispute might be another way. But exactly,
I mean, things
yes.
like putting up fences, putting down fences.
Exactly.
That sort of thing, and also the fact that your clients never presumed to say that they owned Brook Barn.
Indeed, my lord, yes. And what I'll do, if I may, is I'll make those points good by reference to the authorities which...
Yeah,
the
well,
leading
we'll
authorities.
come to those, but in a sense, you're entitled to say, I mean, I'm speaking aloud and not to see what your argument is, not to express a view, but you would be entitled to say that it would be a strange state of affairs if on a second appeal we were suddenly to come to the conclusion that it was a property dispute when everybody had been litigating
About
so far on the basis that it was a pretty common or garden boundary dispute.
My lord, yes.
Right, so that's your case on that.
Yes, yes. But rather than sit down now, if I may develop it a little more, I'd be grateful. So, just briefly before we move on, the position then under the 1925 Act was that in a case which was properly analysed a property dispute, as my Lord Justice Newey said, the remedy would be to apply to rectify the register. And that legally made sense because of section 70 of the 1925 Act, which your lordships will find on page 12. Overriding interest, yes. So this is section 70, and what subsection 1 tells us is that all registered land, unless the contrary is expressed, is deemed to such overriding interests as for time being subsist. And then, my lord, down at little f, there is, subject to the provisions of this Act, rights acquired or in the course of being acquired under the Limitation Acts. So it's not controversial between us that an adverse possession or right under adverse possession that had been acquired or that was being acquired would have overrode first registration. And then, my lords, if you turn to...
Just pausing there, on the judge's findings, both sets of your clients had acquired title by adverse possession long before first registration.
Indeed, my lord, yes. In fact, in the case of the rights, he said it was no later than about 2000, which was some 13 years before first registration.
And the date in respect to the Claphams?
And the date, I don't think he gave a date in respect
12 years, because he said they started occupying the disputed land as from the purchase.
Yes, well, they occupied from 1996, but their predecessors in title, as the judge found, had been in occupation of the land before them. So what he did was he took the two periods of the squatters together and added them together. So he wasn't asked to specify a date by which title had been extinguished.
It doesn't matter as long as it was
before first registration.
Which was March 2000.
March 2003, indeed.
And that he expressly found.
And that he expressly found, and there's no appeal against that finding.
So we are actually only concerned with rights acquired, not rights in the course of
Yes, my lord.
acquired.
Yes.
And in fact, just following up that there hasn't been an appeal, either a first or a second appeal, against any finding of fact.
That's right, my lord, yes.
So the facts are all preserved in the judgment of Judge Hedley, and it contains all the facts that are necessary.
It does, my lord. And with due deference to the judge, it is an impressively detailed judgment. What we're not challenging is the way that he set out the facts. It is simply the analysis which resulted in him finding that the title which the rights and the Claphams had long before first registration acquired was somehow revested in or lost to Ms Narga through the chain of conveyances that resulted in her being the registered proprietor.
And in March 2003, as you say, 71F applied. If 71F hadn't applied, I dare say 71G would have applied, but it doesn't matter because 71F applied.
Yes, my lord, yes. So that, in the case, again, of a property dispute, the right of an adverse possessor overrides first registration, and that engages section 82, which is on page 17. And it's that which gives the power to alter the register. The word used here is rectification, which of course has taken on a different meaning under the 2002 scheme. But what your lordships will see is section 7082, section 82, G. And my lords, if I can just also show you subsection 3 on page 18.
But it would also fall under 82(1)A and probably B.
Yes. The scheme is comprehensive. And in fact, yes. So that's the scheme of the 1925 Act.
And you were taking us to subsection 3 to say, well, there might have been difficulties over rectification, but for the fact that there was an overriding interest, but because there was an overriding interest, there would have been no problem.
Indeed, yes. Yes. So the scheme under the 1925 Act was different from the rectification alteration scheme under Schedule 4 to the 2002 Act. But I show you those sections, my lords, because that applies in a property dispute where what is needed is for the register to be rectified. But just to be clear, my case is that if the general boundaries rule applies, there is no mistake on the face of the register, because the boundary which is shown is only a general boundary. It is not conclusive as to the ownership of land on the boundaries of a registered estate. And so it does not have the effect of conclusively vesting in a proprietor land on the boundary of the registered estate which has previously been extinguished, or title to which has previously been extinguished under the Limitation Acts by adverse possession. And so the person's remedy in that case, if they, for instance, taking what my Lord Justice Nugee put to me earlier, suppose someone registers title to their property with a general boundary, they don't have to give notice to their neighbours. Suppose for a second the neighbours looked at the title and said, well, actually we'd like to make sure of this. Their remedy is for them to apply for first registration of their land, or if they're already registered, their remedy is to apply for a determination of the boundary. But that is the machinery which applies, because there is no mistake which needs to be rectified.
You don't have to do it through a land registrar. You could have a dispute in court. You could have a trespass or injunction claim.
My lord, you could, yes.
Ask for a declaration as to where the boundary is.
Yes, my lord.
And then once that's been determined, you could then take it to a land registry and say, please will you redraw the file plan in accordance with the judgment of the court.
Indeed, my lord, and it won't have escaped your notice that that's what the claimants sought in this case. Because they'd gone for the injunction and because their primary case was one of construction, the adverse possession claim, although it is that bit of the claim which has reached your lordships today for reasons which you'll pick up from the judgment of Mr Justice Leech, that was their fallback, but it was all wrapped up in the same claim, and it was all justiciable properly by the county court judge. And what we sought was a declaration of our entitlement to be registered, which we then would have been able to take to the land registry, apply for first registration, and then if we'd wanted to, apply under the 2002 Act for a determined boundary by reference to His Honour Judge Hedley's judgment.
You say apply for first registration. Your client's title to their properties is registered.
Yes, but
So with general boundaries.
with general boundaries.
So in your case, wouldn't it be a case not of applying for first registration, but saying I've already got a registered title, and now we know where the boundary is, it extends up to there?
Analytically, my lord, I don't think that's right, because what the judge found was in fact that the paper title boundary followed the south bank of the brook. What the consequence of that is that there was an area of land beyond the paper title boundary of which all of the claimants had, or to which all of the claimants had obtained title under the Limitation Acts. On my case, that land was not registered within Ms Narga's title, so analytically what it leaves is a strip of land.
Why is it not registered in your title? Well, that depends on whether they'd already acquired title
Before registration. Yes, which, checking the timeline, I don't think that they had.
Well, it may be that the Claphams had, because
Yes, of their predecessory titles,
Predecessors.
yes,
who've been there quite a long time. So it may be by the time the Claphams were registered,
yes.
they'd already acquired, they and their predecessors already acquired title. So as
Yes.
I understand your case, under the general boundaries rule,
Yes.
their registered title would include that. But it wouldn't apply to the rights who hadn't acquired title by the time they were registered. Is that right?
Indeed. Well, my lord, I want to clear nothing turns on this for today's purposes, because this just goes to the way that the application would be framed to the land registry. But I still think that analytically, even in the Clapham's case, what was conveyed to them was a paper title going up to the south bank of the brook,
I see.
and also a possessory title of the land to the north of the brook, and indeed the treehouse land,
Yeah.
which is on the that's the basis on which the judge proceeded. So analytically,
Treehouse was the rights.
no, that was to the west of the Clapham's property at number 24. So again, this is an interesting academic question.
Yes, I'm sorry. I
Uh,
don't
No, that's fine. Well, it's
Can
an
you
interesting
just
one.
fill in the picture for me at least? Well, you have a court ruling on an issue of this kind, where the judge says, well, that's where the boundary is between the two properties. What then happens so far as registration is concerned after that? What use can you make of the of the legal order?
One can apply for first registration to the land registry. One relies on the court's determination, which says you are entitled to be registered with title to this land pursuant to the Limitation Acts. The land registrar gives effect to that by creating a new legal estate, on my analysis. Then after that, you can say, right, great, we now want the line of the boundary to be determined precisely in accordance with land registration rules. Or from Ms Narga's point of view, armed with the declaration against her, if you like, my lord, she would then be able to apply to the land registry and say, okay, well, fine, it's been determined against me, but what I would now like is for my boundary to be determined exactly, and the land registrar will do that.
Right, so it's up to one or both of the parties to a boundary dispute as to what use they make of the order, but they have a remedy if they want to make sure that the registered title accords with the court judgment.
Indeed, my lord. But they don't have to do anything.
They don't have to
They
do it.
could
They
just
can-
keep hold of their declaration, though they would be unwise to do so because a subsequent
As you say,
purchaser...
it would be untidy.
It would, my lord, it would be untidy, but if either of the parties were to sell the land, there would be an argument that the judgment wasn't binding on them.
Right, so having had a boundary dispute, the participants would be well advised to see the matter through
They would, my lord.
afterwards in order to make sure that there was no further issue.
Yes,
And either of them can do it in the manner that you've described.
Indeed. So let me come on then to the first decision on the property dispute, boundary dispute distinction that I want to look at, and that is the 1957 decision of the Court of Appeal in Lee and Barry, which is behind tab 8 of the authorities bundle. And that's page 101 for those using it electronically. Now, the facts, of course, in every boundary dispute are critical. So what I would ask your lordships to do first of all is just to read the summary of the facts on page 101 in the head note. So that's page 101, my lord. So your lordships will see this is another dispute which arises on quite unfortunate facts. If I could ask you now to look at paragraph 1 underneath held. And then also the summary at paragraph 2, and then I'll take your lordships into the judgment.
Yes.
So, my lords, if we could now go into the judgment of Lord Eversheds, who's then Master of the Rolls, on page 104. The last two paragraphs on that page says, I must say that I feel some considerable sympathy for the defendant, since, having regard to the view I take, it must be allowed that he has paid dearly for the assumption he has made, but I have already indicated that I think it inescapable that he was wrong. The case was put most clearly before us by Mr Salt for the plaintiff, and I think I can do no better than to summarise the course which his argument took. He pointed out that if one looks at the transfer plan and bears in mind the circumstances of its preparation, the visit to the site and the identification of the pegs Y and S to which I have already alluded, there can be no doubt whatever about what were the boundaries of the property which the defendant had bought and had intended to buy. Therefore, Mr Salt said, apart from any argument which can be derived from the language of the Land Registration Act 1925 and the rules made thereunder, this might be called a textbook case. So what was being said there is that the title plan is clear. It was prepared by people who had a full understanding of the layout on the ground, and it ought to prevail. But then, if we come on to the third paragraph, the case for the defendant. Sorry, this is on page 105. The case for the defendant has rested upon the view taken and advanced of the effect of the Land Registration Act 1925 and of the statutory provisions upon the land certificate, which is undoubtedly the defendant's document of title. Mr Ploughman referred us to sections 19 and 69 of the Act, which provide that the transfer shall be completed by an entry on the register, and that when that entry takes place and the certificate is issued in respect of it, then by section 69, the proprietor is deemed to have vested in him what the certificate certifies that he owns. And then his lordship sets out the statutory scheme, and then in the paragraph in the middle of the page, it starts in those circumstances. Goes on to say, as we are concerned with a general filed map or plan, the sole question for us is whether, notwithstanding the transfer and the facts I have mentioned, the effect of the statutory provisions, sections 19 and 69 in particular, is that as matters stand, what the defendant has and is entitled to say he has is a piece of land identified by reference to the map on his certificate. And the argument is that if you look at the map, it is as plain as possible that there is no question of an angled division. The piece of land of which the defendant is certified as proprietor is regular in shape. It is in fact identified by reference to two pegs, which can be shown to be in a straight line from the respective corners, and the defendant contends that if the significance of my, I've skipped a slide, that the plaintiff desires to say that is wrong, then what he should do is to make an application to rectify the register. That was the significance of my reading of the claim in the writ and the statement of claim. And then he goes on, and this is where his analysis really starts. It seems to me, therefore, in the end of all, that the matter comes down to this, in the light of the statutory provisions and looking at the land certificate. Is this a case in which the defendant can, as things now are, say, I have got a piece of land, the boundaries of which are sufficiently identified and are such that my house at no point trespasses upon the plaintiff's property? Or, on the other side, is the right answer that the identification in the certificate is not, and does not purport to be, a precise signification, a precise showing of the boundaries, which boundaries can properly be discerned from other material in the case. That is the point. And then he reaches his conclusion, important bit of reasoning, on the final paragraph on page 105. The second sentence, picking it up there, he says, I would go with Mr Ploughman this far, that a boundary dispute and a property dispute may be two things quite different. It is true that a property dispute may and frequently does involve boundaries, and that a boundary dispute involves in some degree a property dispute. And if the divergence is very great indeed, you may say that the matter has passed from any sensible use of the phrase boundary dispute and become something else. But applying the common sense test, if, as Mr Ploughman invited us to do, you put the question here, is the plaintiff saying, in truth, that the defendant got the wrong property by the land certificate? I would answer the question negatively. I think, for my part, that there is no doubt that the certificate purported to give him and gives him the right property. What, on the evidence it has failed to do, is to indicate its boundaries with sufficient correctness and precision. And over on page 106, my lord, if I can just show you the judgment of Lord Justice Romer, who concurred. What he said is that it is, of course, fundamental to Mr Ploughman's case that this dispute ought properly to be regarded not as a boundary dispute, but as a property dispute, because if it is in fact a boundary dispute, it cannot succeed for the reasons which the Master of the Rolls has stated. For myself, I can only say that I have no doubt but that this is a boundary dispute within the usually accepted sense of that expression. Maudsley divided up this land, which he owned, into 5 parts, numbered 1, 2, 3, 4, and 5, and there is no doubt at all but that it was his intention to sell, and it was the intention of the defendant to buy, plot number 4. And there is no doubt but that in substance the defendant had plot number 4 conveyed to him. Therefore, it seems almost impossible, to my mind, to say that this is a property dispute in the sense that the wrong property was conveyed to the defendant, because he had conveyed or transferred to him the plot which he intended to have, namely plot 4. And in the final paragraph, he says that when one cross-checks that against the extent of the land in question, that just reinforces his view that this is a boundary dispute and not a property dispute. Now, pausing there for a second, my lords, this, of course, is authority for the operation of the 1925 Act, and therefore it is relevant to the question, what was the effect of first registration of Brook Barn under the 1925 Act? And in my submission, it's squarely on point here. If we go to Ms Narga's title plan, which is again behind the particulars of claim in the main bundle, so that's tab 11, on page 230, so if we apply the common sense test as it was referred to by Lord Evershed as Master of the Rolls and say, is Ms Narga saying in truth that she got the wrong property by her land certificate? In my submission, the answer to that is a resounding no. What the title plan shows is that she had conveyed to her Brook Barn. But what the title plan has failed to do is to indicate the precise boundaries of Brook Barn with sufficient correctness and precision. My lords, I'd now like to come on to the 2002 Act. And it's worthy of note that as a boundary dispute, this is particularly interesting in that it traverses both unregistered land and limitation and the 1925 Act and the 2002 Act. If we go to the 2002 Act, that's behind tab 4 in the authorities bundle. And if we could go to section 58 on page 28. So this is the statutory successor to section 69 of the 1925 Act. So this is where, under the 2002 Act scheme, the statutory magic is found. So if on the entry of a person in the register as the proprietor of a legal estate, the legal estate would not otherwise be vested in him, it shall be deemed to be vested in him as a result of the registration. But the conclusiveness of that is qualified by section 60, which is over the page, which is the source of the modern general boundaries rule, the successor to section 278. And what this tells us is that the boundary of a registered estate as shown for the purposes of the register is a general boundary.
It's a successor to Rule 278.
Rule 278, my lord, yes. So it's a general boundary unless shown as determined under this section, and a general boundary does not determine the exact line of the boundary.
I mean, presumably there are plans for the sale of very large estates in which the mere line on a page might cover tens of metres
Or more.
hundreds of
Yes.
metres,
Indeed, my lord,
depending upon the scale of the plan.
Indeed.
So, I mean, a rule about a plan has got to apply not only to small domestic property, but also to large agricultural property.
Quite so, my lord. Yes. But my lords, having shown you that, I just want to come quickly to section 29, which is on page 26, because it's on this section that Ms Narga really hangs her case. So this is the section that deals with the effect of a registered disposition of a registered estate.
Page again.
Sorry, my lord.
Page.
Page 26. And this, I confess, that I've always found in practice one of the hardest provisions in the 2002 Act to understand. But what it tells us is that if a registrable disposition of a registered estate is made for valuable consideration. Completion of the disposition by registration has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition whose priority is not protected at the time of registration. Now, what I say about that, my lord, is that the interest under the disposition is only the land to which Ms Narga's predecessor in title had title. That is the extent of the registered disposition. And taking into account the operation of the general boundaries rule, is that it's not conclusive for all of the same reasons we've been through as to what is actually disposed.
We're only talking about a disposition of a registered estate, and the physical extent of a registered estate is dependent on whether it's been registered with fixed boundaries or general boundaries.
Indeed, my lord, yes. So, what I'd now like to do is come on to the leading case on the property dispute, boundary dispute under the 2002 Act scheme, and that's Drake and Fripp behind tab 13 of the authorities bundle. So this is a 2011 decision of the Court of Appeal, an all-star cast of Lord Newberger, then Master of the Rolls. I'm sorry, he was Lord Justice Newberger, then Master of the Rolls, Lord Justice Lewison, and Lord Justice Aikens. And Lord Justice Lewison gave the judgment, but again, because the facts are important, and I think will be particularly important for how this issue breaks on the present case, just ask you to read the head note at 2 on page 251. So your lordships will see this was not in fact a boundary dispute in the classic sense. It was a dispute about whether an alteration to the register would amount to rectification or not. In other words, would the effect of the alteration of the register involve removing title from a registered estate? But in my submission, it makes no difference. The context in which the claim arises makes no difference because the principles which are elucidated and applied by Lord Justice Lewison are of general application to whether something is a boundary dispute or a property dispute. If I could ask your lordships next just to read H5 of the report, starting correction of the title plans would not amount to rectification.
Sorry, what page are we on?
My lord, I'm on page 251 of the authorities bundle. So this is the property and compensation reports, and it's paragraph H5 in the head note.
H5, yes, I'm sorry, I thought I just read that. Yeah.
So if your lordships have all processed that, the relevant parts of Lord Justice Lewison's analysis at this point start on page 257. He introduces the issue at paragraph 14. And then the last sentence, my lords, of paragraph 16 says, alteration of the boundary shown on the title plan would undoubtedly correct a mistake, but would it prejudicially affect SLA's title? In my judgment, the answer to that question depends upon whether SLA acquired title to the disputed land as a consequence of the way in which the filed plan, now the title plan, was drawn. And he summarises the appellant's position at paragraph 17. Just ask you to note that. An echo of that may be heard this afternoon in my learned friend's submissions. And my lords, you'll see that he refers then to rule 278 at paragraph 19. and in fact 18, sorry, paragraph 18, he sets out Rule 278, the old general boundaries rule, and then at 19 he sets out the new general boundaries rule under section 60 of the 2002 Act. And then the reasoning, for our purposes, in paragraph 20, he starts by saying, well, in substance, section 60 is the same as the former rule, i.e. Rule 278. But even if that is incorrect, it is not suggested that the revocation of the 1925 rules could have enlarged SLA's title. Rule 278.2 said in terms that one of the matters left undetermined was how far a boundary ran beyond a hedge, fence, or wall. Accordingly, in my judgment, the registration of SLA as proprietor by reference to a filed plan on which the boundary line followed the Cornish hedge left the position of the precise boundary undetermined. Once the position of the precise boundary had been retrospectively determined by the adjudicator and the judge, it could be seen that SLA never had title to the disputed strip. And therefore, Mr. Falkowski's proposition that SLA had lost 1.5 acres of land is thus either question-begging or wrong. He went on to say, nor do I accept that there is some limit to the quantity of land that might be encompassed in a boundary dispute. It must depend on all the circumstances and in particular the quantity of land abutting the boundary. And he develops that reasoning a little bit. Then he goes on to quote from the judgment of Lee and Barry and to approve essentially, or to adopt the common sense rule that Lord Justice Evershed applied. And finally, my lords, can I just show you 22 on page 259, a paragraph that may resonate in particular with my Lord Justice Nugee. What he says is the same point can be put in a slightly different way. The boundary currently shown on the title plan is a general boundary. If the title plan is altered so as to show the boundary running along the line of the fence, it will still be a general boundary. In Derbyshire County Council and Fallon, the Deputy Adjudicator, Mr Michael Mark, described this as producing another general boundary in a more accurate position than the current general boundary. His observation was quoted with approval by Mr Christopher Nugee, QC, on appeal to the Chancery Division, and expressly approved by this court in Strachey and Ramage.
I have no recollection of that at all.
You'll be pleased to know, my lord, it's not in the authorities bundle and we shan't be dragging your lordships through it. But again,
Just before you move on,
yes.
you say this is actually the same as the first sentence of paragraph 20. We are not actually concerned with section 60. We're concerned with the old rule.
Yes, indeed, because the old rule will have applied on first registration. And, so
and it won't have got any bigger.
yes, the point his lordship makes is applicable. It can't have been enlarged by the revocation of the old rule. But more generally, as I think his lordship...
Well, actually, neither by the revocation of the old rule, which took place in October 2003, nor by, on your case, the subsequent dispositions ending up...
Indeed.
There were a series of dispositions ending up with Miss Narga.
There were. And
But you showed us section 60, I think.
yes,
Not section 20 something.
29.
29. Where what one's talking about is a disposition of a registered estate, and it vests that estate
Yes.
in the successive proprietors. So as I understand your position, if it, in March 2003 it was registered with general boundaries under the 1925 rules,
Yes.
the same applies even though we're now looking at Miss Narga's position, which was registered under the 2002 Act.
My lord, yes, that's exactly my case. Yes.
Yes, I think I understand your case. Yes.
Yes. But what I say about this reasoning is that it's again clearly on point here, because the boundary that we're looking at is broadly similar dimensions to that which was in issue in Drake and Fripp. And
What was the width in?
in Drake and Fripp, it was, I think, 4 to 5 metres at one point. That was the widest.
Amounting to 1.5 acres.
Yes. Now, we don't, I'm afraid, have the dimensions of how much is in dispute on this appeal, but we do know that broadly speaking, if we look again at the sketch plans, which I showed your lordships earlier on, behind tab 11 of the main bundle on page 241, one gets from that a sense of the dimensions of the disputed strip between the south bank of the brook and the fence, and the dimensions are comparable.
And Lord Justice Lewison says it doesn't matter how long it is. If it's a thin strip along a canal, it might amount to many acres.
Indeed.
hectares.
Yes. Yes, in my submission, the critical point really is that where a title plan purports to delineate a boundary as following one of the classical boundary features identified in Rule 278, so hedge, fence, wall, ditch, stream, it is in particular not to be taken as conclusively representing that that is the boundary. That's really what Rule 278 goes to say.
Sorry.
No, after you. Well, it's probably inconsequential, but the general boundaries cases that you've been taking us to don't have the overlay that we've got in this case of Limitation Act. The rights having arisen under the Limitation Act, they were about situations which didn't concern adverse possession.
Yes. But the principle, as I said,
Principle you say is the same.
is a broad application. The question is simply, does one look at the title plan and see from the title plan that it unequivocally concludes that a particular piece of property is included within the registered estate? In that case, one is in the realm of a property dispute, whether it's an application for rectification of the register or whether it's in the case of a boundary dispute. But if in fact one looks at, if we can just, let's go to Ms Narga's title plan now on page 230. So if one is looking at a plan of this nature, which the judge's finding was that the red line follows a line on the plan which was intended by the drawer of the map to indicate one of the banks of the brook. That is a classic case where the title plan shows a boundary following a particular feature, but under Rule 278 it was not to be taken as conclusive that the boundary in fact did.
I mean, to be fair, the authorities perhaps go a bit further than the wording of 278 might itself suggest, because 278 says, well, you know, is not determinative as to which bank of the stream.
Yes.
Is not quite saying what you get in the later cases, obviously.
But 278 is worded in terms of what it states are simply examples. So it says, for instance, so it's not supposed to be a conclusive or exhaustive list. The question, as the authorities have gone on to make clear, is that it's always a question of fact or degree. But if I can just develop this point, assuming for a second that the judge was correct, that the title plan here does follow the bank of the brook, in my submission it is nonetheless within the general boundaries rule, because adopting the reasoning in Drake and Fripp, it is not conclusive as to how far from the bank of the brook the real boundary lay. And there's some obvious sense in that because, of course, as the judge found, the water level in the brook fluctuates from year to year, from month to month. So there will be times of the year when the water level is high up the bank and it's impossible to see underneath the waterline, the line which the judge thought was the edge of the brook, which the plan denoted. A problem which I flagged on the appeal against his construction of the conveyances, but not immediately relevant here. But my lords, if I can put the point in a slightly different way, as in Drake and Fripp, assuming the boundary, as we're told by section 60 on this plan, or indeed by Rule 278 on first registration, assuming that it shows a general boundary, to echo what my Lord Justice Nugee, sitting as a deputy judge then in Derby and Fallon, said, the redrawing of the boundary on Ms Narga's title plan would simply produce another general boundary in perhaps a more accurate place. But it would still just show a general boundary. And my lords, what is meant by that, or the effect of that analysis, is that the redrawing of the line on the title plan would not have the effect of definitively removing any land from Ms Narga's title.
That means she wouldn't get any compensation.
Indeed, so if this were an application for rectification, that would be so.
Because on your case...
Sorry, application for alteration, not for rectification, because on my case it wouldn't be a rectification.
Because on your case she never bought and never got a registered title.
So we're in exactly Drake and Fripp territory.
Yes.
Only in that case it was in some respects clearer because it was agreed that there were two boundary features shown on the plan, the fence and the Cornish hedge, and the title plan wrongly, it was agreed, showed the boundary as following the Cornish hedge rather than the fence. I might have got that the wrong way round. But here there was no agreement about what the plan shows. The plan in my submission is insufficiently clear to delineate the various candidates for the boundary feature. The judge, as an aside, although it wasn't part of his decision, hypothesised, or in fact, no, he concluded, I think, that the red line was intended to show the north face of the south bank of the brook, which was as things happened, consistent with where he'd found that the boundary was, having considered the paper conveyances. I might, if I may, just indulge yours in a quick thought experiment, because I think the point could be taken a little further. If this were not a boundary dispute, one might ask, well, in that case, why couldn't the Claphams, for instance, also be able to contend that their title plans conclusively showed where the boundary lay? And we can see their title plan at page 219. And your lordships will see it's a rather vaguer, more high-level plan, but there'd be nothing to stop them, in theory, from asserting that the red line on their plan showed the north bank of the brook, or perhaps even the line of the fence.
At the same time, the drawing doesn't encourage that sort of analysis.
Well, perhaps so well, but I make the point only to
Yes.
immediately to stop myself and say, well, of course they can't do that, because the general boundaries rule is such that the title plan is not conclusive as to how far from any physical boundary the paper title runs.
Yes.
So, wrapping up this bit of my submissions, returning then to the common sense test, in my submission, every party to this appeal clearly got the right property, but the title plans set the boundaries to each with insufficient exactitude. And so my case throughout has been the general boundaries rule applies, the land in dispute is within the scope of the general boundaries rule, first registration showed a general boundary only, it was inconclusive as to the precise extent of what was registered, the title plan is of no assistance in showing where the precise boundary lies, no claim for rectification needed to be made because there was no mistake, and therefore we're entitled simply to the declaration that we seek. My lords, if I can just back that up, if I may, by briefly referring to the commentary in Ruoff and Roper that my Lord Justice Newey's clerk drew to the party's attention a couple of days ago. I should apologise immediately that this escaped both of us, but so far as we can tell, the edition was updated after we put our skeletons in. So this is fairly recent commentary, but if your lordships look at the penultimate paragraph in section 33060 spot 05, just above the section headed pre-application checklist, it's the paragraph that starts, it might be suggested that a contrary approach, given the boundaries of the registered estate have not been fixed or determined, would have been for the general boundaries principle to be applied so as to provide the court with the flexibility to take account of the extinguishment of the paper title to the strips of land prior to first registration, and therefore conclude that the registered estate did not include that land. On that basis, the provisions of section 29 of the 2002 Act would not be engaged. The squatters would retain their unregistered common law possessory estate in the land and could apply for first registration of that estate if they wished, and or apply for alteration of the title plan of the registered estate so as to show the boundary in a more accurate position. Now, that analysis, obviously, I adopt and urge upon your lordships. That summarises what my case has been throughout and what it is today, and it has the support there of the learned editors of Ruoff and Roper.
Can I just ask about that? I mean, looking at the decisions below, I mean, especially the decision of Mr Justice Leech, the focus is so much on section 75, whereas, as you've argued the matter this morning, section 75 doesn't really matter. Is that because the shape of the case has changed, or?
My lord, no. What I wanted to do was just to start off, essentially from first principles, saying clearly by reference to the authorities what I say is the answer here. And having done that, I then want to go and deal with the way that section 75 came up and caused the case to be decided against me, not on the basis that Ruoff and Roper's editor suggested might have been a way of determining the case.
Yeah.
So if I can briefly then come on to my learned friend's case. What the thrust of his case is that the general boundaries rule does not produce the effect that I say it does, But it's helpful to consider why that is said, because when your lordships look at the respondent's notice before this court and the skeleton argument, you will see that it is said to be a result of the way in which the case was pleaded. So if we look at the respondent's notice behind tab 15 of the main bundle and on page 273.
Where are we in your 5-point plan?
My lord, having ambitiously said I anticipated being finished before lunch, we're on stage 2, but I hope that I can trot through the rest at a more rapid rate, having laid the groundwork.
Yes.
So this is section 2. Paragraph 1 on the respondent's notice. The first basis for upholding Mr Justice Leech's judgment is that what the appellants needed to show in any event was an overriding interest regardless of the effect of section 75. But my lords, what you will see from his skeleton is that this focuses entirely on what interest the appellants had in the strip of land. And that, in my submission, is looking through the wrong end of the telescope, because the question is not what interest did the appellants have. The question is, since the appellants extinguished title to the disputed land before first registration, what then is the juridical root of the respondent's title, or rather of the respondent's predecessor's title, which she says was conveyed to her? And the focus then needs to be on first registration, and I'll come on to that. But just before we leave the respondent's notice, your lordships will then see there's a second basis for upholding Mr Justice Leech, which is that the general boundaries rule is somehow ousted because of the way the appellants pleaded their case below. Just want to look at the way those are developed in my learned friend's skeleton, which is behind tab 16, page 280. And my lords, if I could take you straight to to page 284. And this is paragraph 18. So my learned friend's starting point is section 29 of the Land Registration Act. And then that's developed at paragraph 19, where he again starts to talk about the nature of the appellant's interest and whether it overrides. But in my submission, the flaw in this approach is that it assumes what needs to be demonstrated, which is that Ms Narga's predecessor in title obtained a registered estate in the disputed land, which could then be conveyed to Ms Narga. Because, of course, the appellants would only need to show an interest which overrode the disposition to Ms Narga if Ms Narga had an interest in the land in question which needed to be overridden. So my learned friend's reasoning in my submission is missing this critical step. Ms Narga first needs to explain how it is that the extinguished title became vested in her predecessor on first registration. And, my lords, you will see that the respondent's skeleton argument is silent on that point. There is a suggestion, though, but I put it no higher than that. I think my learned friend will develop this orally later. There's a suggestion of what her case might be in the second argument introduced in the respondent's notice, which is that because the case was pleaded in the way it was, somehow that means Ms Narga had title. If we turn and look at page 291 in paragraph 47, what is submitted there is that this is not a case where the general boundaries rule applies. HHJ Hedley determined where the boundary was between Brook Barn and the appellant's property. He did this. My lord, sorry.
It's probably because I've been jumping between versions of the skeleton. So paragraph
paragraph 47, and I don't understand this to have changed in the updated skeleton that my learned friend filed a few days ago.
I'm probably looking at the wrong thing this one. I think I am looking at the wrong thing.
Internal page 12 of his
Yes,
skeleton assessment.
yes, I've got that.
So this is the submission that the general boundaries rule does not apply here, and it appears to be said that that is because HHJ Hedley determined the boundary and was asked to do that. And that is developed at paragraph 49, where he says, by its nature, the claim for adverse possession was a dispute about title. That is reflected in the way the claim is pleaded. But my lords, of course it was. Every boundary dispute in some way, shape or form involves a dispute about title, as is clear from the two cases that I've taken your lordships through. But
Yes.
what, with respect, my learned friend, is confusing is the title which a proprietor obtains at the level of land registration with the paper title which lies beneath the register. Because the land registry title plan shows a general boundary unless the line of the boundary has been determined not by a judge but at the land registry under the land registration rules under section 60 of the 2002 Act. But if that determination hasn't happened, the land registry title plan will still show a general boundary regardless of whether a judge has turned their mind to identifying where in law beneath the register the boundary lies. And a judge in carrying out that determination, of course, will need to turn their minds to possession, to the underlying deeds, and of course, maybe even to what the parties between them have agreed. But just because a judge has done that does not mean that the general boundaries rule ceases to apply to the title plan. So, if what Ms Narga intended to submit is that the way the case was pleaded means that this has become a property dispute and not a boundary dispute, that in my
We have your
respectful...
submissions on that.
Yes. So, come on then to the judgments below. I think, my lords, I can deal fairly quickly with that of Mr Justice Leech. The point which I don't think is in dispute between us is that his lordship decided this appeal solely on the basis of section 75. And what I mean by that is that his lordship understood section 75 to have been engaged upon first registration of Brook Barn, and that on his analysis it was section 75 which did the work of vesting in Ms Narga's predecessor in title, a title to the land that had been extinguished. And one sees that in the paragraphs at the end of towards the end of his judgment, where he says that the title dispute, boundary dispute, was a red herring. And the critical paragraph, really, of his judgment for the purposes of this appeal is, or are 75 and 76 on page 78 of the bundle. So in other words, I don't think this is disputed between us. Mr Justice Leech thought that the root of Ms Narga's title today was just section 75 and not the fact of registration coupled with the title plan coupled with the statutory magic.
But the funny thing about that, as I know you effectively said, is that you're only into section 75 if section 75 is capable of applying at all, if what is registered encompasses the disputed land.
Indeed. But I think, my lord, his lordship below looks at it slightly differently. He thought that the title included the disputed land because of section 75.
But that I can't really follow.
Well,
I mean, if the registered estate includes the disputed land, then you have your dispute over whether section 75 applies.
yes.
But if the registered estate doesn't include the disputed land, well, section 75 can't apply.
Well, there is a tension in that regard in his judgment between paragraph 75 and 76, where he said, in my judgment, once the judge had found as a matter of law that section 75 applied, he was bound to come to the conclusion that the registered title included the strip.
But that seems to be putting it the wrong way around.
But nonetheless, that is the way that he understood the trial judge to have reached his conclusion. And I'll show you His Honour Judge Hedley's judgment in a second. But the obvious tension is between that and what he then goes on to say at paragraph 76, which is, for what it's worth, but for section 75, I would have found that the general boundaries rule applies. This was a boundary dispute and therefore section 29 never bit. So it is something of a puzzle, my lords, I accept that, but my reading of the judgment is that his lordship thought that it was section 75 which put the land back into the registered title and not the other way round. That's how he analysed it. And for the reasons which I've set out in writing in my submission, that is wrong. And my lords, if in fact he decided it differently, and in contrary to what he said here, he thought that somehow the effect of registration was to revest the title to the title that had been extinguished in Ms Narga's predecessor's title, and then section 75 applied, that was still wrong for the reasons that I've been through. This was a boundary dispute and not a property dispute. And so if that was his reasoning, which it wasn't because of what he then goes on to say at paragraph 76, it would nonetheless be wrong.
76 you like, 76 is
Yes,
fine.
if you put it like that.
Yes, but I mean, supposing that this hadn't been a dispute about the strip we are concerned with, but a dispute about a large field,
Yes,
then on the face of it, registration of Brook Barn with the large field
Yes.
would definitely be a property dispute.
yes,
And at that stage, you'd have your argument over whether Section 75 applied or not.
yes, but one wouldn't need to worry, frankly, because it matters not whether the appellant's interest was an interest under Section 75 or an interest acquired under the Limitation Acts. And what the appellant's interest is neither here nor there. Once Ms Narga has established a root of her title, the question then becomes, was there an overriding interest, whether under any of the sections we've looked at?
And I follow that, but it isn't immediately obvious to me that supposing that Section 75 had not applied, with the result that your clients would have had to apply for alteration or rectification, that right would have survived the sale to Miss Narga. But maybe there's some argument about that that hasn't been addressed, if you see what I mean.
Oh, I see, perhaps, my lord. In other words, if our interest was one which arose under Section 75, we had an entitlement under 75(2) to apply to be registered, whereas if it was an interest which just arose generally under the Limitation Acts, then the remedy would be rectification, pure and simple. Yes, I accept there is that potential distinction, but I don't think anything turns on that today, because the question is, what is the root juridically of Ms Narga's title? If she has one, then I accept that we need to show an overriding interest, and that creates great problems for me. But if she doesn't have one, because the general boundaries rule operated throughout, then the correct analysis is that which I've urged upon you for the last hour and a half or so, and which is expressed by the editors of Ruoff and Roper in the passage that we just looked at. And indeed, which is consistent with the paragraph that my Lord, Lord Justice Jackson, has just taken us to, which, as he puts it, I like.
Right, well, just taking stock of where we've got to, because I'm anxious that nobody is under pressure of time and we can't sit late this afternoon. You've taken us to Mr Justice Leech. Any more on him, his judgment?
My Lord, no, I propose now just to move on
Yes,
to...
I think it would be good if you were able to complete your submissions by perhaps 12:30 as you had.
I will endeavour to do so. I just very quickly then want to go through the approach that His Honour Judge Hedley took.
Yes.
So, my Lord, his judgment is behind tab 9.
So very large parts of this are uncontentious,
Yes.
indeed, better than that. And you're going to take us to where you say he fell off the
Yes.
the road.
Yes, indeed, into the ditch, perhaps.
Yeah.
One might say in the context of this dispute. Because the point I just want to make about this judgment, my Lord, is that it is clear that His Honour Judge Hedley did not proceed on the basis that this was a title dispute. What I mean by that is that he proceeded on the basis that the land in dispute was within the scope of the general boundaries rule. And my lords, if I give you these references for your note to look at later, I'm not going to take you through everything now. But paragraph 17 of the judgment on page 131, he summarises what Ms Narga understood her title plan conclusively to show. That's the basis on which she started erecting the fence. I say it's clear that he didn't decide the case on that basis because Ms Narga conceded that the plan showed only a general boundary. That paragraph, or that concession rather, is recorded in paragraph 92, little n, on page 159.
Sorry, paragraph 92.
92n, 159. This, my lord, is a summary of Mr Gale's submissions on behalf of Ms Narga. So in fact, her case, as it turned out, was not based on the title plan. It was based, and this is her case on the line of the boundary and point of interpretation. In fact, what she said was, well, I say it's at the top of the bank because there was a boundary fence there. Now, that contention is rejected at paragraph 100, little g of the judgment on page 164. But what I say is that the concession that the general boundaries rule applied meant that the judge rightly understood that this was in play here. My lords, next, if I can just give you the references to where he sets out the legal principles which govern the dispute. Starting at paragraph 31 on page 134. In that paragraph, my lords, I'll invite you to read it in full, but what is clear is that he's aware that registration of title is not intended to change the boundary with adjoining properties. Even if the land certificate or transfer appears to be plain, it may conflict with the neighbouring title. Therefore, it may be necessary to go behind the registration to discover the true and original boundary. And then, my lords, again, just for your note, on page 137 at paragraphs 38 and 39, he sets out in full the general boundaries rule under the 2002 Act. And at paragraphs 39 and 40, quotes some extracts from McGarry and Wade's Law of Real Property, which explain clearly the effect of the general boundaries rule. And at the end of paragraph 41, it's clear that he understands that the fact that the land registry plan depicts a particular line as the boundary does not operate to confer title up to the line where the ad medium filum presumption exists. So the judge's approach very clearly here, doesn't once refer to the statutory magic, is that this is a dispute within the general boundaries rule. And my lords, just very briefly refer you to some places where the judge made clear that he understood the dangers or the difficulties of relying on land registry title plans. Your lordships will see he remarks at paragraph 45 on page 139 that the title plan in respect of the Claphams and the Wrights property doesn't show the boundary as being in the right place. It shows it as being a straight line when in fact there's a kink. Also, my lords, at...
sorry, which paragraph was that?
That was paragraph 45 on page 139. Then next, paragraph 89 on page 155, he analyses Ms Narga's title plan. And makes clear that it's not accurate and that there are dangers of relying on it, over on paragraph 90. And finally, well, there's an important comment at paragraph 102, which is on page 165. What he says here is, in my judgment, Ms Narga is mistaken in her reading of the plan. Then says, leaving aside the general boundaries rule, in my judgment, the title plans were intended to depict the banks of the brook. He then unpacks that a little bit. But then at the end, he says, although I accept that there is only one line for the brook to the west of the land in question, none of the plans are needing to set out accurately the position to the west. In fact, the boundary being the southern edge of the brook would accord with the 1982 conveyance plan. In my judgment, that is what the title plans are seeking to denote. But the words leaving aside the general boundaries rule in that paragraph show that he understood that a title plan could only purport to show a boundary line if the general boundaries rule were left to one side. but his summary of the law and Ms Narga's concession make clear that he was not leaving the general boundaries rule to one side in his analysis of the case. And that point is reinforced, my lords, by his summary of the submissions on this point. One would have thought that had he understood that he was being asked to determine the extent of the land registered within the title to Brook Barn by reference to the title plan, he would have referred to section 69 of the 1925 Act or section 58 of the 2002 Act, the statutory magic provisions, and made clear that that is what he was doing. But my lords, if you go to page 174, here he summarises Ms Narga's submissions on this point. Slightly problematically, he takes as his starting point section 11 of the 2002 Act, which is the provision that deals with first registration under that Act. That was, of course, not an issue in the case. He then goes straight on to section 29. And then when he gets to paragraph 131, my lord, his summary of the submissions incorporated the flaw that I directed your lordship's attention to earlier. It assumes what needs to be established, which is that there is a root of Ms Narga's title to the disputed land.
He's not purporting to decide this, he's just reciting this.
He's reciting the way the case was argued before him. Yes, my lord, sorry, that's not clear.
Right, so we haven't yet got to the point where things go wrong, according to you.
We are on the verge of doing so, my lord.
Right.
And then it's also just worth noting that just at the end of that, from paragraph 134, he only refers to the transitional provisions which incorporate the interest under a trust under section 75, not the others. And then paragraph 135 is an important one because this sets the seeds for where in my submission he goes wrong. It says the effect of the transitional provisions is that where title had been acquired by adverse possession under the Limitation Act 1980 and prior to the commencement of the 2002 Act, brackets, and the registered estate was held on trust for the squatter, not having been registered, see Jordan, that's adverse possession by Stephen Jordan KC and Oliver Adley Gardner KC. He simply just refers to that and then from that says, well, that's why you need to show an overriding interest. And my lords, we see where he incorporates that reasoning, where he comes to his analysis and reasoning over the page on 177. I pause to note that at paragraph 140, he accurately summarises the submissions that were made to him by the appellants, which is, well, general boundaries rule means we don't need to show an overriding interest. So what I say is that it is clear that he was seized at the fact that he had to explain why the general boundaries rule did not operate in the way that I said it did. That is because of what he made of section 75. So, my lords, at the bottom, at little b, he sets out the quotation from paragraph 2148 of adverse possession. And it's the middle sentence of that that's important. If title to the land was first registered before the 13th of October 2003, it seems likely that the Land Registration Act of 1925, section 75, would have applied, so as to make the registered proprietor the trustee for the title for the squatter from the moment the title was registered. Then over the page, his analysis is at C, and he adopts that. Says the position here is that title to Brook Barn was registered before the 12th of October 2003, and therefore, although the rights claimed to have acquired title by adverse possession by 29th of October 2000 at the latest, that gave rise to the then owner of Brook Barn holding the title to the disputed land relating to numbers 25-26 as trustee for the rights under section 75. Therefore, we needed to show an overriding interest. And my lords, that reasoning is on its face slightly unsatisfactory because it appears that he assumed that section 75 operated at the moment when title was extinguished rather than the moment when title was first registered. But what is clear in my submission is that he thought that it was section 75 of the 1925 Act alone which was doing the work of revesting in Ms Narga's predecessor in title, the title to the disputed land which had already been extinguished. And he comes on at E to deal with my submissions on the general boundaries rule, I don't accept that he accurately summarises my position in that paragraph. But what is interesting to note, my lords, is that he does not reject my reliance on the general boundaries rule because the title plan was determinative of what was registered and because this was therefore a property dispute and not a boundary dispute. And that, my lords, is why in my submission, Mr Justice Leech framed his conclusion at paragraph 75 in the way that he did. Once the judge had concluded that section 75 applied, he was bound to find that title to the disputed strip was included with first registration. The title dispute, property dispute, was a red herring.
So sort of E and F are saying, well, the 2002 Act cases for boundary disputes.
Yes.
So we really don't have to worry about whether or not it was a boundary dispute.
Yes, but he doesn't engage at all with the submissions that I made that the effect of the general boundaries rule from the off means that there is no registration.
I wonder if there's a simpler explanation of his judgment. The way it was argued, for perfectly understandable reasons, was did you get title to the disputed strip as a matter of construction of your original conveyances? Because if you had, then you said, well, I don't need to rely on adverse possession, I've got a paper title, and so that's good enough.
Yes.
And he rejects that, because he finds on the construction of the conveyances, the physical boundary at the time of the conveyances was along the south bank of the brook.
Yes.
And then he assumes that that's where the boundary is between the two plots, so that when Brook Barn gets registered, the disputed strip, which is north of that, is included in the registered title. If that's right, then, depending on whether Section 75 applies on first registration, where title's already been extinguished, which is a separate point, but he accepts that from Jordan, then it would mean that Miss Narga would have title to the disputed strip, but it would originally have been held under the trust under Section 75.
I follow, my lord. So I think what your lordship is putting to me, well, is it not possible that he assumed or proceeded on the unspoken assumption that this was in effect a property dispute, not a boundary dispute?
No, it was a boundary dispute.
Right.
That he had determined where the boundary was as a matter of construction of the conveyances.
Yes.
And then assumed that because that's where the boundary was as a matter of construction,
Yes.
then when the title to Brook Barn was registered, it did include everything up to the boundary which you already found was included in the conveyance.
I see. Yes, my lord.
Whereas I think your case is, but that ignores the fact that between the date of a conveyance and the date of registration, the title, the unregistered title of Brook Barn to the strip had been lost, had been extinguished.
Yes, between first registration and the conveyance, rather than between the conveyance and first registration. But yes, my lord, that is an error. If His Honour Judge Hedley proceeded on that basis, then it incorporates that error, which again flows from what I say is his failure properly to deal with the effect of the general boundaries rule at first registration.
Is it right to understand, looking at the judgment, you've taken us to paragraphs 141 and 142, that really the entire argument is encapsulated within those paragraphs? That if we then go on from 143 through to the very end, which is in the 180s, there's nothing about that that we need to consider or look at. It's simply that you argue that he was then engaged in an exercise that shouldn't have been engaged in at all.
Yes, exactly, my lord, because what he then said was, well, because there is a juridical root of Ms Narga's title, you need to show an overriding
So
interest.
all of that is, if you're right, irrelevant. And the only part of it that you need to challenge is 187C, which is where he very helpfully, as it were, draws his total conclusion together.
Yes, the analysis in paragraph 141.
Because if the judge were right in his analysis up to that point, you know, the rest of it follows, doesn't it?
Yes, exactly.
They're all findings of fact.
Yes.
And
Well, because he then had to go on to say, well, were you in actual occupation and would your occupation have been obvious on a reasonable inspection
so
of the
in
land?
the end,
Sorts of fact.
when one looks at this very comprehensive judgment,
Mm.
really it all feeds into 2 paragraphs.
On this point, it does, my lord, yes. There are other bits of the judgment which are challenged on his findings about the construction of the conveyances, but that's a separate point, not for today. But yes, my lord, that is where I say it goes wrong. And that was understood by Mr Justice Leech as having been, or Mr Justice Leech understood the reasoning not on the basis that my lord, Lord Justice Newey put to me a second ago, but it was understood by Mr Justice Leech that the judge thought that section 75 revested title. And my lords, briefly, we haven't looked at this yet. Can we just go to section 75? Because if I can show you the language of it.
My point before we leave this is that if you don't succeed on that argument, then you don't, as we have in some cases, you don't then present other arguments that say, and even if I'm wrong about that, then he went wrong again later on.
No, my lord, because I don't challenge his
Anything
factual
after
findings.
those
He had the
paragraphs.
benefit of the site visit, he heard all the evidence,
Yes.
he saw the photos, he was in the position to say whether he thought, based on what he'd heard, the inspection was in point of fact, sorry, the occupation was in point of fact, obvious on a reasonable inspection. So all I say is that if he has gone wrong here in identifying a
I mean,
juridical
if he was right about that, in your submission, he wouldn't have needed to have done anything else.
yes, if he got it right and adopted the reasoning
Yes.
of the alternative reasoning of Mr Justice Leech, he wouldn't have gone on to consider anything else. Well, I suppose he might have done the alternative, but he wouldn't have needed to, because the critical point would have been there is no juridical root of Ms Narga's title, and therefore we don't need to show an overriding interest. That unregistered strip, to which title was extinguished before first registration, survived first registration, and simply the appellants were entitled to be registered.
Thank you. Sorry, you were going to go on.
Going on quickly to section 75 of the 1925 Act, which your lordships will find behind tab 1 and on page 15. And the reason I draw attention to this at this stage is because it is worth noting that the target of section 75 is not just the interests of the squatter, it is also the interests of the paper title holder. Because what it says is the Limitation Act shall apply to registered land in the same manner and to the same extent as those acts apply to land not registered, except that where, if the land were not registered, the estate of the person registered as proprietor would be extinguished, such estate shall not be extinguished, but shall be deemed to be held on trust by the proprietor for the time being. So in other words, section 75 is not just concerned with telling us about the interest that a squatter obtains, it also tells us something about the effect of adverse possession on the paper title, which is, or but for the section, would be extinguished. And the reason, my lords, I draw attention to that is because I think it illuminates why, in my submission, His Honour Judge Hedley and Mr Justice Leech thought that section 75 had this positive effect of revesting title quite apart from the other provisions that were engaged on first registration. And that, when one reads Mr Justice Leech's judgment, in my submission, is how he understood His Honour Judge Hedley to have decided it, and it's also how he decided it. That is problematic for all of the reasons that your lordships have been throwing at me from the bench, but that is how it's been dealt with below. So section 75 does stand as the kingpin that needs to be knocked down if these arguments are below are going to be swept aside. So to that extent, I differ from the analysis of the editors of Ruoff and Roper in the passages that we referred to. What they say is that this was a case of mistaken representation because of first registration, and section 75 then acted to create a trust, the editors suggest, in fact, that on their view, Section 75 didn't appear to make a difference to the case. But what's clear from the passages in Mr Justice Leech's judgment is that he thought of it the other way round, and in fact, Section 75 did make all the difference in that case. But, just to make a brief policy point, before I come on very briefly to Section 75, what the editors of Ruoff and Roper say in the alternative is that the general boundaries rule should do the work here, because it blunts the effect of first registration and gives the court the flexibility to give effect to historical positions on the ground. In my submission, very briefly, there are obvious reasons why that should be the case, because otherwise, my lords, in cases where title was extinguished perhaps many, many years, even decades ago, before first registration, where title plans which purport to show a boundary following a traditional boundary feature, such as a hedge, a fence, a ditch, a street. If such a plan was taken as determinative of the position of a boundary, then what would follow is that in a large number of cases, first registration will have had the effect of realigning boundaries that had been long settled by use and possession on the ground. And the consequence of that, if title plans like Ms Narga's in this case were allowed to have that determinative effect, would be that a single conveyance under the 2002 Act, in circumstances where the adverse possession were not obvious on a reasonable inspection of the land, would have the effect of legally resetting the boundary permanently along a line which is completely at odds with the line that is actually treated as the boundary on the ground.
Can I understand how far you go? I mean, on the way you've been developing the case, Section 75 doesn't perhaps really matter, but we nevertheless have to worry about what it does, even if we otherwise ended up taking your view of things. So let's suppose a slightly different case, where there would plainly be a property dispute. So let's suppose that in 1900, somebody acquires title to 2 fields.
Yes.
He gets one by a conveyance, he gets one by adverse possession.
Yes.
Along comes the 1925 Act with Section 75 in it. And then, let's say in 1975, there's a mistake at the land registry for whatever reason, and somebody else is registered as the proprietor of the 2 fields.
Yes.
Now, so far as the field that had been acquired by conveyance is concerned, you're into alteration, rectification,
Yes.
blah, blah, blah. Section 75 doesn't come into it.
Yes.
But if Section 75 applies, then as regards the other field, the one that was acquired by adverse possession, legal title is taken away from the person who has had it, or his successors have had it since 1900.
Yes.
And at that point, the land is held on trust for that person. And it comes to be vulnerable under the 2002 Act in the ways that we see through the 2002 Act.
Yes.
So we do need to worry about whether that's right.
We do.
And the Ruoff and Roper line is, well, they're only expressing an argument, but they're saying it's arguable, and this is certainly an argument that was rejected below, that Section 75 doesn't apply where title has already been extinguished.
Yes.
Does that remain your position so far as you may think it matters?
It does. And can I come straight on to that now? So this is the 4th section of my submissions.
Yes, I see.
Really, I think I've set this out fully in my skeleton. So just for your notes, my lords, it's the section on the analysis of the statutory language, paragraphs 25 to 30, and the section criticising the judge's analysis, which is paragraphs 31 to 41. Now, the answer to this, in addition to the linguistic analysis which I've set out, which commend to your lordships, can also be found in the Marylebone Property Company litigation, which I accept that neither of us knew about or knew of its potential relevance before the appeal before Mr Justice Leech. So
Do you say this is ratio binding on us, or is it obiter? Or?
this is a very difficult question, my lord, and I'm going to show you why it's a very difficult question, if I may now. If we start with the Court of Appeal's judgment, that's behind tab 9 of the authorities bundle.
Yep.
Now, the facts of this case, your lordship think this is an unfortunate dispute. This dispute concerned, I think, 1/4 of a shed in Hampstead, so hopefully that is some helpful context. The facts are summarised in full in on pages 116 to 118, but I, for the your lordship's benefit, have attempted to distill them into a few sentences, which I'm going to go through now. So it was a claim for possession of 3/4 of a shed in Hampstead which straddled 2 gardens in numbers 311 and 315 West End Lane. The 2 adjoining properties had been leased to separate lessees in 1894 for 99-year terms. The shed, all of it, was wholly used by the owners of number 311 in a way which was adverse to the title of 315, so as to cause time to run under the Limitation Acts for the requisite period. It was agreed in that case that the lessee of number 315, that's the lessee, was thereafter barred from ejecting the owners of 311 from that part of the shed in which they were in adverse possession, In 1959, the lease of number 315 was surrendered to the freeholder, who then, having an estate in possession, sought to recover possession of the relevant part of the shed from the owners of 311. Now, the owners of 311, in their defence, contended that they could not do so until the term of the surrendered lease had run. So, the issue before the court in this litigation was whether a trespasser who had been in adverse possession of land subject to a lease for long enough to have extinguished the lessee's title could rely on the unexpired term of the lease as a defence to the claim for possession by the lessor after the lease had been surrendered. And one can see why the Section 75 point might have some bearing on this, because the argument was that if Section 75 applied, then there was a separation between the legal title to the lease and the beneficial title, and if what had been surrendered was the legal title, well then there would be the residue of the term under the Section 75 trust, which might still give the trespassers a defence to the possession claim. What the Court of Appeal held was that the surrender of the lease meant that time started to run afresh against the trespasser, to run afresh against the freeholder in favour of the trespasser, so that the surrendered lease could not be relied upon as a defence. Now, the point about Section 75 wasn't argued at first instance. It was brought in, apparently, on an application to adduce further evidence on precisely when title to the lease was registered. That was dealt with by Lord Justice Holroyd Pierce on page 126. Now, he deals with the point very briefly. He observes that no permission for further evidence is going to be given, so it's impossible to know whether Section 75 might have any bearing. What he does say is that it clearly deals with the future, not the past, and therefore the point fails. So there was insufficient evidence for the court to know whether it would make a difference. That was then appealed to the House of Lords.
When Lord Justice Holroyd Pierce says, had Mr Lazarus been able to establish that the leasehold title was registered before the Act came into force, what does he mean there?
Well, exactly what he says. So what he didn't address his mind to here was whether there needed to be evidence that the lease had been registered before limitation had run. He didn't say that in those terms.
How could you register a title before the Act came into force?
Under the previous Limitation Acts, under the previous Registration Act.
So the Act there is the 1925 Act, is it?
Yes. Yes, sorry.
It's not the Limitation Act.
It's not the Limitation Act, I'm sorry, my lord. It's the 1925 Act, but there were predecessors to the 1925 Act dealing with land registration, so it would nonetheless have been possible to register title before the 1925 Act came into force. But the point to which his lordship addresses his mind there is not, I accept.
Well, presumably there was some evidence as to when the 12 years had expired.
There was a finding made about that, but there was no evidence of whether that happened before or after first registration, and the Court of Appeal refused permission to adduce that evidence. But then the matter came to the House of...
Just before you move
Yes.
on, I see the argument on this, you see at 505.
50...
Page 505 internally, 115 of the bundle.
Sorry, 505115 of the bundle. Yes.
Where you see Mr Lazarus explaining things and Lord Justice Holroyd Pierce saying that the court wasn't disposed to allow fresh evidence at this stage, and Mr Lazarus said he wouldn't pursue the point.
Yes. Indeed. Yes, I'm grateful, Lord. So the point was addressed simply on the basis of this application to adduce new evidence. But then it comes to the House of Lords.
So really, it goes nowhere whatever in this court.
Indeed, my lord, but it comes back in a different guise in the House of Lords decision, and that's behind tab 10. And if I can take your lordships to the summary of the argument on page 162. Your lordships will see about 3/4 of the way down the page, there's a heading Land Registration Act 1925. And complaint is made, first of all, there's no reference to this in the pleadings. They were not called on to argue the question in the Court of Appeal, but only addressed argument in this connection on the application to adduce further evidence. So on that basis, I think it was certainly obiter in the Court of Appeal. But what Lord Radcliffe then says is, well, we'd like to hear argument on this question taking the same view of the facts as were taken by the Court of Appeal. So in their lordship's house, it seems that they did want to hear full argument upon the point, and the summary of the argument indicates that they did hear that argument. And that takes us to the speech of Lord Radcliffe at page 176, where he deals with this. Starting about 2/3 of the way down the page. We have been in a little difficulty over a point which was argued for the appellant with regard to the operation of section 75. They then say, well, we're really unsure about what this provision is, how this provision works. But I won't read it out to your lordships, you'll see it. What he does then go on to say on page 177, referring to the judgment of Lord Justice Holroyd Pierce. He says, my lords, I agree with this view in the sense that I regard section 75(1) as operating only upon events occurring after the Act came into force, and if the Limitation Acts effected extinguishment at a date when the lessee was not a registered proprietor, the subsection would not operate. He then goes on in the next sentence to say, I do not think, therefore, that the appellant can succeed on this point. And so I think, I've said in my skeleton that this point is obiter, but I think there is one analysis of this case, and I've given my learned friend notice of the fact that I think it can be analysed in this way, that this could be said to be part of the ratio of the decision, in that, albeit in this peripheral sense, it is a crucial step in the reasoning of the court in refusing permission to appeal. Sorry, in dismissing the appeal. But, my lords, regardless of whether it is obiter or part of the ratio, it is nonetheless, in my submission, very persuasive authority which supports my reading of section 75 of the Act, which is that it only operates if the limitation period expires after first registration and can have no effect if limitation expires before first registration.
And just so far as it may matter, and you're sort of saying it doesn't really matter, in terms of working out whether it's part of the ratio of the decision, so I see at 543 that, or 178, Lord Guest agrees with
Yes.
Radcliffe, so that's 2.
Yes, and Lord Denning then deals with it at the end of his judgment as well, which is on page 183.
But he's a bit more. It's not really open, and he doubts if it does anything. It's less decisive.
It is less decisive,
Lord Morris dissents.
and Lord Morris dissents in general, but I think on the section
Doesn't say anything about
75
section
one issue, he
75.
says, yes, he expresses no view.
I mean, this is a 4-judge House of Lords, is it?
Yes.
I mean, if so, then two out of 3 of the majority must be the must provide the ratio, presumably.
2 out of 4 of the majority.
The
There's a
majority,
majority
there's
of
only 3
3.
of the
Oh,
majority.
yes.
And of those, two out of 3 say what Lord Reed says.
Lord Radcliffe.
says.
Yes.
So if it would be ratio in Lord Radcliffe's decision, it would be ratio in the House of Lords, presumably.
Yes, I think that is right, my lord. But I may have to go away over lunch and have a look at cross on precedent to make sure that I'm not saying something which I shouldn't be. But as I say, my lords, regardless of whether it's ratio or obiter, it ought to be very persuasive. And so to take my Lord Justice Newey's case of the field which was wrongly registered, field obtained through adverse possession and field obtained through conveyance, both wrongly registered. In my submission, the position would be same for both of them. There would be a mistake. The overriding interest would arise under the inoccupation bit of the 1925 Act. But section 75 would not operate unless title was extinguished after the title to the field was first registered.
All right, so you've asked us to think about whether we're bound by this, but you're not yet able to simply say that's the end of the matter. And we are.
My lord, I'm sorry, that is unsatisfactory.
No, not
point
at all.
on
No,
which to
I
end
can,
my
the
submission.
whole thing is very unsatisfactory. It appears to be have been dealt with in a quite unusual way in that case. So, but at the moment, I mean, I think Mr. Gale is entitled to know whether he's being told that's the answer and nothing we can do about it. I think you're putting it in a more balanced way.
I am. I'm saying at the moment that it is persuasive, and I will check the point about the rule on a 4-judge House of Lords if I can find an answer over lunch. What I don't propose to do is deal now with section 5 of my submissions, which was to deal with what Mr. Gale was going to say orally. I'll do
Well,
that.
I think it is more satisfactory all ways round if Mr. Gale has more elbow room, and
Right,
that
yes.
should leave you with adequate time to reply to anything that needs
Indeed, my lord.
a reply. Is there anything else to flag? No, thank you very much indeed, Mr. Morris. Yes, Mr. Gale.
So, my lords, I could start on the on the point covered by my learned friend about section 75.
Would that be convenient, as it were, so as it's fresh in our minds?
Yes, and then I'm going to address you on the general boundaries rule and the Ruoff and Roper extract, to which you've helpfully directed our attention. But I may need a break. If I could have a break I may not be able to finish before lunchtime.
Oh, of course not. No. It's just you now have the time up until lunch, and we'll then resume at a normal time this afternoon. But as I say, to give you warning, I'm afraid we're not able to sit late today, so it doesn't seem to me that there'll be any difficulty in concluding the argument within the normal court time.
I'm grateful.
Good.
So I'll start with the construction of section 75, and in the course of doing that, I will deal with the fair weather point as well. Section 75 of the 1925 Act is a deeming provision. That's what Mr Justice Leech said, and I would submit that is the correct characterisation. There's authority on the interpretation of the deeming provisions which I've provided. In the case of Fowler and Revenue and Customs Commissioners decided in the Supreme Court in 2020, which is found at page 280 of the authorities bundle. And the relevant passage is found at page 288. And there are five points. But what is clear from that is that the deeming provision creates a statutory fiction. I would say that this is a revenue tax case, but it is applicable in other cases as well. I haven't cited it, but there is a Companies Act case decided in this court, Tradition Financial Services. It's not in the authorities bundle because it's not directly relevant, but this is not just a tax deeming case. But what my submission is clear from this is that one should, particularly subparagraph 2, if I can take you to subparagraph 1, the extent of the fiction is primarily a matter of construction of the statute in which it appears. And then number 2, for that purpose, the court should ascertain, if it can, the purposes for which persons between whom the statutory fiction is to be resorted to, and then apply the deeming provision that far, but not where it would produce effects clearly outside those purposes. So, looking at the whole statute, it's not entirely clear if one applies this backwards to the case in Fairweather. It's not, just on that basis, it's not certain whether the tenant in Fairweather would have been able to avail himself of this statutory fiction. Well, I'll come back to that because I'd like to take you to the exercise of interpreting in accordance with Fowler. And I will draw your attention to section 5, which is on page 8 of the authorities bundle. This is the section which ought to have been referred to by His Honour Judge Hedley. He refers to section 11 in the new Act, but it's understood that the property in question was first registered under the 1925 Act. But this, in my submission, is part of the analysis of the purpose behind the whole statute. And this is vesting provision, so that when anybody is vested as the registered proprietor, the whole estate is vested in them.
Is that strictly a deeming? I mean, it's an achieving provision.
The section 75, I would say, is a deeming provision.
Not section 5.
Not section 5, no. It's section 75 that we're construing. And I say section 75 is a deeming provision.
Yes, does it?
And this, yeah, it does deem as well, but this I would call a vesting provision.
Okay.
But it's an aid to the construction of the purpose behind the statute. And my learned friend has taken you already to section 69, which is on page 10 in the authorities bundle. And page 70, section 70, which is on the following page 12.
Yeah.
Which sets out exclusively and exhaustively the overriding interests. And in my submission, the purpose of section 75 was to simply provide a proprietary right which recognises the acquisition of title by adverse possession in registered land. The underlying purpose of the registration regime being to create certainty where land is registered under the Act. So for those purposes, the trust, in inverted commas, is a statutory fiction. It's there to achieve a purpose and to clothe the squatter with a right, which can then operate as an overriding interest. and it does so under the 1925 Act and under the transitional provisions.
The purpose is to provide certainty where land is registered. Certainty about what?
About who owns the land.
But not the precise extent of the land.
Well, I'll come on to the general boundaries rule, but yes,
that's-
there is the general boundaries rule exists, and I'm not going to attempt to convince your lordships otherwise.
But can I be sure I understand what your submission is? Your submission is that on first registration, if the title to the land has already been extinguished in unregistered conveyancing, nevertheless, the effect of first registration, see section 5, is that the registered proprietor gets the fee simple, and that is by section 75 then held on trust for the squatter. Is that your submission?
That's correct. Yes, that's my submission. So it's section 5 which vests the title in the registered proprietor, subject to a trust, or subject to the rights in section 75, which has been a deemed trust.
And it really doesn't matter. You're quite right that Section 75 uses the word deemed, but I'm not quite sure what difference the word deemed makes, in the sense that there is a trust, isn't there?
Well, there's a trust for certain purposes, but it's not to be under the authority of Fowler. It's only to be taken as a trust for certain purposes. It's a statutory fiction.
So just to understand, the person who had legal title before has lost it. That's not a statutory fiction. It's happened.
Yes.
And instead, by Section 75, a trust is imposed. Why is that a statutory fiction? Is it not a trust?
The trust is imposed on registration, not on extinguishment.
No, sorry, yes. But I'll go back. So somebody acquires title to land by adverse possession. Then, for whatever reason, that land is the subject of registration in favour of someone else. But someone else gets legal title to the land because of Section 5. And then Section 75 says there shall be deemed to be a trust. Why isn't that that is a trust, isn't it? What different is it? In what sense is it not a real trust?
Well, it may be a real trust, but it's deemed to be a trust. I'm not sure for these purposes there's any real difference. But what I'm suggesting is that this is a question as to whether the trust should come into being on registration, despite having been extinguished. And my learned friend is arguing that it can't retrospectively create a trust. And what I'm saying is that argument is beside the point, because whatever kind of interest it is, it's simply an interest which is there for the convenience of affording the squatter a right, notwithstanding the indefeasibility of title owing to registration, which is provided for by Section 5.
I'm not clear why, under the 1925 legislation, the squatter needs that protection of the trust. Because in a case in which the title has been lost, the unregistered paper title has been lost as a result of Section 17 of the Limitation Act, but someone nevertheless gets registered, the squatter surely is in a position to apply under the 1925 scheme for rectification of the register on the grounds that someone's been registered who shouldn't have been. Isn't that what Section 18 says? Was it 1882?
Yes.
The registrar is satisfied an entry has been obtained by mistake or G, where a legal estate has been registered in the name of a person who, if the land had not been registered, would not have been the estate owner. So why do they need to have the protection of a trust? Why can't they just apply under section 821G and get their land back?
Well, it's an overriding interest. The section 70 1F expressly provides for an overriding interest. So I suppose there are two routes.
Yes,
There's
but
the estate and-
before, if we call the adverse possessor A, and the person who manages to get registered B, before B is registered, A has got a possessory title, which once the 12 years has elapsed, there's a perfectly good title against the whole world. He's extinguished everybody else's rights to the land. It's got a good title. It's a possessory title. It's not a paper title, but it's still a good title. That's a legal title. It's not a beneficial interest. A legal title to the land. Someone else, B, manages to get themselves registered as proprietor of the same land. But they wouldn't have done it. They wouldn't have had any title if it was still unregistered. So we know that section 5 gives B a fee simple, but it's subject to overriding interests. And one of the overriding interests is, as you just pointed out, section 71F, which is rights acquired, as well as rights being acquired, rights acquired under the Limitation Act, which exactly fits A's case. So B's statutory fee simple is subject to A's unregistered legal fee simple, which is a possessory title. So B wins, A wins, and A can go under section 821G and get the register rectified. Now that all makes perfect sense. I don't understand why you need a trust at all in those circumstances. Whereas I do understand why you need a trust where the estate against which you have adversely possessed for 12 years is already registered. And the reason there is that in unregistered conveyancing, the person who's been out of possession for 12 years, their estate just disappears, it's extinguished. The difficulty is you can't extinguish someone who's on the register because they're still on the register. And as we know, section 5 and section 69 give them a fee simple. So the mechanics are, instead of saying it's extinguished, they still have it because we know they have it, but now they have to hold it for the adverse possessor. So I can see why section 75 is needed where when the 12 years elapsed, the title is already registered, but I don't see why it's needed where the 12 years elapsed before first registration.
Well, I don't have an answer to that. Other than that, it is a right, and it's in my submission. It is the right that is meant by section 70 1F, the right acquired under the Limitation Act. The extinguishment of title, the right to be registered, is a right to be acquired under the Limitation Act, and that must be what section 71F is referring to when it says rights acquired under the Limitation Act, being an overriding interest. My learned friend has taken you to Fairweather. And I will just take you again to the House of Lords decision on Fairweather and refer you to page 177. My learned friend very fairly accepted that the reasoning in the Court of Appeal was not satisfactory, but in the House of Lords,
I don't think he accepted that. I think we were talking about the fact that the thing had arisen in a very strange way.
yes,
Namely a comment made in relation to an argument that one party sought to get on their feet on the basis of fresh evidence which was not admitted. And so it was really a side wind in the Court of Appeal.
Yes.
I think that was what he was accepting, not that that there was anything unsatisfactory about the
Well, there was
substance.
the point wasn't argued in the
Yeah.
Court of Appeal, and it's not expressed. The reasoning is not expressed very clearly. But in the House of Lords, Lord Radcliffe at 176 in the indicated part says that we have been a little difficulty over a point. And then he says the result is that neither the court nor this house had available enough of the facts to know whether the point had any actual bearing on the case or not. And the last sentence, I think it's best on this occasion to say as little about it as possible.
Right, so that is not a resounding statement, but this is part of the ratio of their decision.
Indeed. And then further down at page 177, after his lordship has agreed with the words of Holroyd Pierce and somewhat perhaps put a gloss on them by adding, and if the Limitation Act affected extinguishment at a date when the lease was not a registered proprietor, that's added. But then he says, I do not think, therefore, the appellant can succeed on this point. I only wish to add that at present I am not at all satisfied that Section 75(1) does create a trust interest in the squatter of the kind that one would expect from the words used. So I would say that even further than not being resounding, indication that it's part of the ratio, I would submit that it really isn't. It can only be viewed as part of the ratio in the light of subsequent decisions which might hold that such a statutory trust does save a tenant in those circumstances. But that's not what was decided in Fairweather, because it was decided that it didn't apply.
Are you moving on?
I'm going to move on. Yeah.
Forget for a moment whether it's ratio or not. Lord Radcliffe says, I regard Section 75 as operating only upon events occurring after the Act came into force, and if the Limitation Act's affected distinguishment at a date when the lessee was not a registered proprietor, the subsection would not operate. Now, whether or not ratio, is that passage against you, or is there an interpretation of it that is not against you?
I would have to say that on its face, that is against me.
Yes, I see.
But I do say
It's certainly not ratio and whatever. Yes.
Dealing with the points in my learned friend's skeleton argument, the criticisms of the judges below's construction of Section 75 are briefly, they are expropriatory, and there's a presumption against expropriatory. This, in my submission, is not an expropriatory section, in that, in any event, the Act provides for an overriding interest. So, in fact, in my submission, the statutory trust, whatever it is, gives the squatter something, and it gives the squatter an overriding interest. It's also not retrospective. In effect, that we're not saying it applies retrospectively in the sense set out in the authority in the textbook, the Benyon Bailey textbook that's in the authorities bundle, which refers to acts having retrospective effect, i.e. before they came into force. Nobody is saying that there was a trust at any time when the 1925 Act was not in force. The 1925 Act deems a trust while it is in force. So it doesn't. We're not attempting to suggest that there was a trust before the Act came into force. What it does is it divides land into two categories: registered and unregistered. And I refer to the reasoning of Mr Justice Leech at paragraph 66. It would have been easy to say that this is except where the title is already extinguished.
that be a convenient moment? Would that be a good moment for us to break? I don't want to cut you off in the middle of a thought. But,
just to sum up my submissions on the actual construction.
yes.
On the text itself, it doesn't only bear a forward-looking construction, because it compares a situation between unregistered land, where title would be extinguished, and a description of the situation in registered land, title not extinguished, as using extinguished as an ordinary adjective to describe the land, title extinguished, title not extinguished, as opposed to an actual act of the extinguishment happening.
Sorry, can I be sure I've understood that? So you read section 75(1) where it says, where if the land were not registered, the estate would be extinguished, not as referring to the act of extinction, but to the state of having been extinguished. Is that
Yes.
That's
right, and,
yes.
and that on a purposive construction is a perfectly acceptable construction, and on a purposive interpretation, that's the purpose of the statutory fiction. Then, otherwise it makes an unprincipled distinction between properties registered according to when properties were first registered, and the underlying principle behind the registration provisions is that a purchaser of land ought to be able to be satisfied of what they're getting from an inspection of the land and an inspection of the register.
Can I, since we're looking at the language, ask you about section 75(2), which confers a statutory right on a squatter to be registered as proprietor. But it's in these terms, any person claiming to have acquired a title under the Limitation Acts to a registered estate. Now suppose you have a case where the squatter has done his 12 years before first registration, and then there is first registration, and on your submission the trust in section 75(1) attaches. Would the squatter be a person claiming to have acquired a title under the Limitation Acts to a registered estate?
Yes.
Yes.
Yes. And my submission is that would act as an overriding interest.
Yes. Even though the way the Limitation Acts work, as I understand it, is after 12 years you bar the paper owner, and therefore your possessory title becomes good against everybody, and so that's how you get the title. And that would have happened after 12 years at a stage in the example when there wasn't a registered estate. There wasn't a registered estate at all. It was all unregistered. But what I'm putting to you is that the person claiming to have acquired a title under the Limitation Act, a registered estate, might be thought to be confined to somebody whose 12 years expires against a registered estate, as opposed to somebody whose 12 years expires against an unregistered estate.
Yeah, and that is the construction contended for by.
But you say the language is wide enough to include the thank you.
I say exactly, and on a purpose of construction, that's how it ought to be construed. I'm going to, after lunch, I'm going to deal with why section 75 actually doesn't. The construction of section 75 doesn't matter, because in any event, what the appellants had was a right under the Limitation Acts, which has ceased to be an overriding interest.
Well, I think that means both of you are saying true construction of section 75 doesn't matter, although that's the main point of the appeal.
Yes.
Yes.
Very good. 2 o'clock.
All right.